So how does a disability insurance company evaluate job or occupational requirements? Really the issue, again, is going to come down to the definition of disability in your policy. So how does that carrier interpret the term occupation? And what is the difference between job and occupation in the policy? If the term occupation or regular occupation is used in the definition of disability, your claim is going to be based on an analysis of the type of work generally performed for employers in the national economy, and not the work that you've performed for your specific employer. On the other hand, if the term job or any variation of job, such as a regular job, is used in that definition of disability, your claim is going to be evaluated based on an analysis of the work performed for your specific employer. Got the difference? So who does that evaluation? I'm going to introduce you to another liar for hire player in the disability carrier's arsenal. That is a vocational evaluator. Now, a vocational evaluator is an expert in the world of work, and they will analyze your occupational requirements and classify that work using a big book called the Dictionary of Occupational Titles, or something called the ONET. Now, what's important about this is that the Dictionary of Occupational Titles is a compilation of occupations in the American economy, and it's based on strength levels. It talks about the physical requirements of an occupation, the cognitive requirements, and the psychological requirements. The DOT will use those strength levels to determine the physicality of the work. The work is classified into a number of categories. There's very heavy, heavy, medium, light, and sedentary. And in each of these classifications, you consider the amount of lifting, standing, walking, and sitting that's required of the job. And the classification of your job becomes an issue at the occupation stage, because they have to take that job and translate it into an occupation. Unfortunately, many disability insurance carriers, vocational evaluators, will purposely misclassify the strength level of your work, or they'll ignore crucial job functions that allow the disability carrier to deny your claim. And that's two of the tricks that they use, either individually or in combination. Now, work under the Dictionary of Occupational Titles is classified into skill levels, and that's primarily based on the length of time it takes to learn how to do the job. The more skills the job or the occupation has, the higher the classification. And this is going to become an issue when you get to the any occupation stage, where the claim, the adjuster has to determine whether or not you have any skills that would transfer to other occupations. So let me give you an example. A specialty within an occupation could be considered an occupation in and of itself: a nurse, a physician, or a salesperson. Now, if the Dictionary of Occupational Titles lists the specialty as an occupation itself, then the insurance company is going to use that specific Dictionary of Occupational Titles. But let me explain this a little bit more. Let's take the example of surgeon. A surgeon is a medical director, but obviously they're specialized because they do surgery. Now, the term surgeon is listed in the Dictionary of Occupational Titles, and the carrier could very well consider your occupation to be that of a surgeon. I don't like that, and I always attack that, but I want you to understand that the carriers will wed themselves to these specific Dictionary of Occupational Titles. And that's where I argue that the Dictionary of Occupational Titles is not valid, that they need to fully develop and consider your occupational duties as a surgeon, or alternatively use the ONET if that argument is available based on the terms of the policy. So you can see that there are problems with how the disability insurance company evaluates jobs or occupational requirements, and all of those benefit the disability insurance carrier, not you. So let's do a deeper dive into the Dictionary of Occupational Titles, because normally that's what your disability policy will refer to as the measure of or tool to use to determine your occupation. Now, the Dictionary of Occupational Titles, as I said, was a compilation of your occupational duties and jobs that are available in the American economy. The problem is it hasn't been updated in a million years, and there are lots of occupations that don't exist anymore, like the elevator operator. And there are many occupations that aren't even covered by the Dictionary of Occupational Titles. And I think that's a big problem. And part of the mistake that many defense carriers, vocational evaluators will make in trying to classify an occupation. They'll try to shove it into what they think is the closest title, when in fact it might be a compilation of a number of titles or simply may not exist in the Dictionary of Occupational Titles. Now, what's the adjuster going to be doing here? The adjuster is going to ask your employer for a copy of the job description or requirements from your employer. And unfortunately, in my experience, many employers have outdated job description forms that don't explain, in fact, what you really do. The adjuster is also going to ask about your occupational history. They're going to ask you to fill out a form. And guess what? That form doesn't always ask the right questions about the physical requirements of your job, much less the cognitive requirements of your job or the social behavioral requirements of your job. So not only is it important to understand how much you have to lift in your job or occupation, how long you have to sit, stand, walk, stoop, and bend, but you may have to prepare reports, compile information, and do presentations, or you might have quotas that you have to meet. And if you don't meet those quotas, you can't do the essential functions or material and substantial duties of your occupation. And many occupations do require you to interact with coworkers, the public, and supervisors. And if you have any types of problems that would interfere with that ability, again, that's something that should be measured and considered. But the forms that the adjuster has you fill out don't ask the right questions. So I always like to supplement them and make sure that everything is covered. Now, as I've said before, your job might be a composite type job. It might incorporate two jobs. And the carrier's vocational evaluator will purposely classify the composite job in a manner that allows the carrier to say that you're capable of performing that occupation. You also may face a situation where you have a dual occupation, and the carrier, vocational evaluator, will purposely mischaracterize that occupation. Now, in my view, that can be a big issue in claims for professionals. Let's say, for example, you're an OBGYN and you can't perform surgery or deliver babies. Now, you might be totally disabled, but if your policy says that if you perform one of the material and substantial duties of your occupation, you aren't disabled. So you might not be able to perform surgery, you might not be able to deliver babies, but you can see patients in the office. And if you can do that, then you won't meet the definition of total disability, notwithstanding the fact that your partners probably wouldn't put up with that. Now, the insurance company may interpret the claim as one in which you're only partially disabled because you can perform the duties in your office and earn money. This is a very complicated area, and there are variations in policy language as to what constitutes material and substantial duties, and that can impact the carrier's decision. In my view, any medical professional or even a lawyer should consult with an experienced ERISA attorney before they stop working and apply for benefits so they understand that policy definition. Now, what's also important in that area is that doctors, lawyers, dentists, we all have billing, and the disability carrier is going to be wanting to look at the billings to determine what your occupation is and what the material and substantial duties of your occupation might be based on the number of procedures you perform, the frequency of the procedures, and how that has changed over time as a result of your disability. So this can be a very complicated area if you are a professional. Now, since I do represent a lot of professionals, there's the issue of the subspecialty letter or rider. If you are a professional, I think if you can get it, you should have a subspecialty letter that exclusively recognizes your occupation as a narrow specialty when the policy is purchased. Now, how your policy was marketed to you by your broker, agent, or insurance company and how your claim is ultimately submitted can influence how the insurance company interprets the claim. So let me give you an example of a dual occupation dilemma. This was a surgeon that I represented who was a hand surgeon. And as a result of his occupation, not only did he do surgery, but he did emergency surgery. He was on calls, and he would see patients and follow up after surgery. Now, he also, by the way, did other surgeries in his practice. He would do elbow surgery and he would do shoulder surgery and some other general orthopedic issues. He became disabled as a result of a rollerblading accident, and he had a fusion of his dominant hand. He had to stop performing surgery and taking emergency call. He reduced his work schedule, and it consisted of clinical and non-surgical orthopedics. But because he had a subspecialty policy as a hand surgeon, the disability carrier paid him his total disability benefits. If he hadn't had that subspecialty policy, the company would have probably taken into consideration how much surgery he did in terms of the elbows, the shoulders, and general orthopedics, how many on-calls he did, and the nature of his practice prior to him becoming disabled, because they were going to sort of parse, if you will, exactly what percentage of his practice was hand surgery as opposed to everything else. And they, as I said, will do that by looking at your billing code numbers, looking at your pre-disability earnings to compare that with your post-disability earnings, and how the nature and number of your procedures have changed. Again, I think it's crucial that before you file your claim for disability, you know whether you have a subspecialty policy and that you get your financial and billing records in order, because those are going to be crucial to the success of your disability claim, in addition to what's in your medical records, because of course you're going to want your physician to confirm that you can't do certain procedures, or the nature of the procedures, or the frequency of the procedures, and how your disabling condition has changed the nature of your practice. So it's got to be backed up by medical records and your billing and financial records. Now, if you're in California, congratulations. Evaluating own occupation claims in California is a whole different ballgame, because the state of California has issued specific guidelines around the definition of disability for long-term disability claims governed by California law. So one of the things I always want to look at is what was the state in which this policy was issued. And you can look at that on the face page of your policy, because that will impact what law governs your claim. Under the terms of California law, the definition of total disability to be used in a group ERISA case issued in California is as follows: a disability that renders one unable to perform within reasonable continuity the substantial and material acts necessary to pursue the usual occupation in the usual or customary way. Now, I like that definition. Why? The policyholder's usual occupation is the occupation the employer routinely performs at the time the disability begins, and the carrier has to consider the duties of the occupation to be substantial and material acts necessary to pursue that occupation in the usual or customary way. Now you can see there's lots of things that you can take apart in that definition to make it favorable to you as the policyholder, but it will require a vocational analysis that goes beyond just the occupational classification under the Dictionary of Occupational Titles. California law requires that the carrier determine the occupation accurately as performed by the policyholder for that specific employer. That's perfect. It's customized to what you were doing at the time you became disabled based on the nature of your occupation. Wow, that's a lot of information. Let's take another break, and I'm going to come back, and now I'm going to talk about the 4 important terms in your occupation policy language that you have to know before you stop working and apply for benefits, or before you appeal a wrongful denial of your own occupation claim.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos regarding your disability application that will assist you in submitting a winning disability application. This is one you won't want to miss. For the next 24 hours, we are giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.